Now, assistance is provided based on a request by developing countries or countries with economies in transition to support wetland conservation. This could involve improving management of Ramsar sites, designation of new sites, promotion of wise use, or for supporting regional and promotional activities. Besides the Ramsar Convention, many other multilateral environmental agreements and other agreements are also of relevance in the context of wetland regulation. These include the Convention on Conservation of Migratory Species of Wild Animals 1979, the UNESCO World Heritage Convention 1972, Convention on Biological Diversity 1992, the United Nations Convention to Combat Desertification of 1994, and the United Nations Framework Convention on Climate Change 1994. Coming to India specifically, India became a party to the Ramsar Convention on 1st of February 1982 with 6 wetlands being listed on the Ramsar list. The Ministry of Environment and Forests is the national implementing authority for the Ramsar Convention in India. Out of the total of more than 2,000 sites which are protected under the Ramsar Convention, however, only 26 sites are in India. Here is a list of the 26 sites that are in India. These are in the states of Kerala, Orissa, Madhya Pradesh, Himachal Pradesh, Assam, West Bengal, Punjab, Rajasthan, Andhra Pradesh, Manipur, Gujarat, Tamil Nadu, Tripura, Jammu and Kashmir, and Uttar Pradesh. Out of the list of 26 Ramsar sites in India, 2 of the sites have already found their place on the Montreux record, which was described earlier. These are the Loktak Lake in Manipur and the Keoladeo National Park in Rajasthan. However, in India, there are a number of other Ramsar sites and several other non-Ramsar sites which are also being threatened by uncontrolled development and illegal encroachments. So far as the regulation of other wetlands in India is concerned, it is worth mentioning that there are 7,57,060 wetland sites in India at least. They cover an estimated area of 50.26 million hectares and account for 4.63% of the total geographical area of the country. The national legal framework for wetland regulation comprises of certain provisions of the Constitution of India 1950, certain specific legislation, and also some general legislation. Insofar as the Constitution of India is concerned, there is no specific reference to the word wetlands. However, the directive principles of state policy, specifically Article 48A, impose a duty to protect and improve the environment on the government, and Article 51A of the Constitution imposes a fundamental duty on every citizen to protect and improve the natural environment, and this explicitly includes lakes, which sometimes fall under wetlands. There is no national law in India on wetlands. However, in the year 2010, wetlands conservation and management rules were published with the objective of conserving and managing wetlands, and they provide the legal framework for wetlands in India at the national level. There are also provisions in, for example, the Environment Protection Act of 1986, the Coastal Regulation Zone Notification of 2011, and the Wildlife Protection Act of 1972, which cover wetlands in certain specific situations. Insofar as the 2010 wetlands rules are concerned, the definition of wetlands is wider than the Ramsar Convention. Let's look at this definition. A wetland is defined as an area of marsh, fen, peatland or water which is natural or artificial, permanent or temporary, where the water is static or flowing, fresh, brackish or salt water. It includes an area of marine water, the depth of which at low tide does not exceed 6 meters, and includes all inland waters such as lakes, reservoirs, tanks, backwaters, lagoons, creeks, estuaries, and man-made wetlands, plus the zone of direct influence, a term defined under the wetland rules on wetlands, that is drainage area or catchment region of the wetlands as determined by the Central Wetlands Regulatory Authority, which has been established under the wetlands rules. The definition of wetlands under the rules suffer from certain limitations, however. Firstly, most of the important wetlands and reservoirs are deeper than 6 meters. Second, the term wetlands under the 2010 rules excludes main river channels without defining what it means by main river channels. It also excludes paddy fields, which provide very important hydrologic and biodiversity support. Under the 2010 rules, protected wetlands is a list which includes the Ramsar wetlands of international importance, wetlands in ecologically sensitive and important areas, wetlands recognized as or lying within a UNESCO World Heritage Site, high altitude wetlands complexes at or above an elevation of 2,500 meters with an area equal to or greater than 5 hectares, and wetlands or complexes below an elevation of 2,500 meter with an area equal to or greater than 500 hectares. In other words, the list of protected wetlands under the rules does not still include all the wetlands in the country. However, the rules provide that the Central Wetlands Regulatory Authority may identify and the central government may notify other wetlands. But the process of identification is extremely long. It is more than 1 year, which means that in the process, very important wetlands could be lost if efforts are not made immediately to protect them, although they may not be included in the 2010 rules. Now, under the rules, there are prohibited activities. In other words, activities that are completely prohibited once something is declared as a protected wetland under the rules, and there are certain permitted activities. The list of prohibited activities includes reclamation, setting up of new or expansion of existing industries, manufacture, handling, storage or disposal of hazardous substances under the concerned rules, dumping of solid waste in the wetlands, discharge of untreated waste and effluents from industries, cities, towns and other human settlements, construction of a permanent nature within 50 meters from the mean high flood level observed in the past 10 years, discretionary power of the Central Wetlands Regulatory Authority may be exercised to specify and prohibit any other activity likely to have an adverse impact on a wetlands ecosystem. We should now talk a little bit about the authority under the rules. Now, the authority, the Central Wetlands Regulatory Authority, has been granted a number of powers under the 2010 rules. These include granting or identifying areas for grant of clearance for regulated activities, and for this the authority is required to specify threshold levels as well as mode and methodology for undertaking activities. This has to be done in consultation with local authorities, appraising proposals for identification of new wetlands, projects or activities, and for determining the zone of direct influence of wetlands. The CWRA or the Central Wetlands Regulatory Authority can also issue directions for conservation, preservation and wise use of wetlands to the state government. It can specify thresholds for regulated activities and specify the mode and methodology for undertaking those activities. An appeal against the decision of the Central Wetlands Regulatory Authority lies to the National Green Tribunal, and the central government has the power to permit a prohibited activity or what is known as a non-wetland use in a protected wetland on the recommendations of the authority. However, it has to show that such a prohibited activity is being permitted for public interest. The decision has to be a reasoned decision. However, as I mentioned, the term non-wetland use has not been defined under the 2010 rules, which leaves some room for maneuver.